Right, good afternoon, everyone. We've had a small break over August, so if you normally are with us, welcome back. And for those that are new, welcome to our conveyancing forums for England and Wales. Ian, as always, is going to lead proceedings, but this is your forum, so please do try and ask as many questions as you possibly can through the chat function, or if you want to speak, I can give you the mic as well. So please ask questions and lead this in a direction of your choosing, as trying to make sure that this is as useful for you as possible. Any problems, please type in on the chat bar and I'll be working behind the scenes to work it out. Ian is going to introduce some guest speakers today who will be speaking on various topics. So thank you very much, Ian. Please commence.
Thanks, Freddie, and thanks everyone for joining us again. Welcome. Yes, I hope you had an enjoyable summer. I don't think people have done a lot of sunbathing. Freddie's been just talking about his trip to Waterloo, cycling trip, which sounds really interesting, and hope you've managed to get some time off, if nothing else, over the summer months. Really interesting today, and that there's lots and lots of things for us to discuss, and so I'm really excited about raising those topics. But as Freddie says, at the end of the day, this is your event, and therefore I'm really interested in you telling me a little bit about topics, etc., that you'd like to explore. So it's not just me sort of throwing things at you and say these are the things we must talk about. It's an open forum, as Freddie mentions. Rena, thank you for that. I'm going to talk about rent charges a little bit before we finish, and there's also some interesting news about the land registry, which I'll share with you again before we finish. So first of all, massive thank you to Freddie and his team at Stewart Title. Stewart Title, great people, providing title indemnity insurance. And again, Freddie, you have an online platform that people can use, but you also have a raft of underwriters, of which you were one, who can assist with regard to bespoke products and can pivot with regard to demands and needs from clients. So if you haven't looked at Stewart Title's website, I would urge you to do so. If you'd like to talk to Freddie and the team about your needs and requirements, be it sort of online policies and facility for online policies, or be it the need for specific policies for unusual items, perhaps of, say, commercial property related nature, then speak to Freddie. I think, Freddie, you're available sort of fairly regularly, and you also have a bicycle and can travel, as I understand it. So again, I'm sure that Freddie can assist, and I'll provide you with his contact details before we finish. And indeed, talking of contact details, there we are. As far as questions are concerned today and any time, do feel free to fire questions at me before the event or after the event so that we can raise it in future webinars. So you don't have to necessarily raise it as an issue during the forum, but you could send me an email next week and we can put that on the agenda for the next occasion. And I'm delighted to say I've got a guest speaker, Jordan Willett from Orbital Witness, who will be joining us at some stage in the afternoon, explaining a little bit about their services, which are really interesting. I always refer this list of websites to people so that you can familiarize yourself with some useful resources. In particular, recently I've been doing some work with regard to boundary issues, and Property Protocols has a boundary dispute protocol, which is really useful for you. And if you haven't seen the Legal Leasehold Knowledge Partnership website, that's worth a look too, in connection with sort of dissatisfied leaseholders, problems and issues with regard to landlords, etc. The other sites I've mentioned in the past. The PLA website is now a subscription service. Nonetheless, the subscription is relatively low, and there's loads of really useful information on that site, particularly if you are dealing with the complex issues relating to easements or residential leasehold matters. Anyway, enough of that. We'll come back to this slide when our friends from Orbital Witness are with us. What I've got are loads of things that I want to talk about. And the first thing I'd like to talk about is Howden Insurance Brokers, who've produced a report on professional indemnity claims. I don't know if you've seen it. If you'd like to see a copy of it, send me a note and I can send a copy of it to you. I do quite a lot of work with Howdens, and nice organisation, very keen and very professional, of course, with regard to facilitating professional indemnity insurance for the legal profession. And they do produce a newsletter information on a fairly frequent basis in which they'll highlight things that they're experiencing and problems that they're encountering with regard to claims. And I thought it was useful spending 5 or 10 minutes or so just having a look at some of the things that they're highlighting. The first and most important thing that they mention in the latest report is the issue of health and well-being and pressure of work, etc. And it's very, very important to understand and appreciate that your firm should have systems for identifying stress and problems with regards to fee earners, and to make sure that you can facilitate aid and guidance for them. The idea of someone putting their hands up and seeking help and assistance can be quite difficult to do that on the basis that there's a feeling of weakness, etc., which is completely misguided. But as a firm and as an organization, stress, overwork, and related problems for fee earners can lead to claims. So again, I mention it because Howden insurance brokers lead with that as an issue with regard to pitfalls that can lead to conveyancing claims. The second thing that they talk about are supervisory issues. And again, making sure that supervision arrangements are in place and that they're kept under review. And again, making sure that supervisors are also managed and monitored with regard to their well-being. Important and interesting. The real nitty-gritty of what they're saying with regard to this report then starts with them looking at buyer-funded developments, and they advise and they report that insurers are taking big hits with regard to buyer-funded developments that go awry. So again, problems with this: obtaining instructions, acting for more than one party, considering the rights and interests of the developer as opposed to the potential buyer off plan. So the advice that is given is tread carefully. There are still buyer funded developments that are coming to market. And again, where you are a firm that's acted in such a scheme, you're going to find that your PI premiums are increasing, and you may well find that insurers are going to lose an appetite to insure. So again, the point I would make is, if you're going to be risk averse, just don't look at the work. Or alternatively, if you are going to do this type of sort of semi-commercial development or entirely commercial development work, that you have safeguards in place and you are ultra cautious with regard to who you're acting for and what you're advising, and in connection with investors, that you're highlighting to them in no uncertain terms their risk and vulnerability. Next thing surprised me, to be honest: imposter vendors, seller identity fraud. Dreamvar and Purensing are now sort of history, aren't they, really? There'll be some fee earners and some conveyancers that can't even remember what the cases were about and never heard of them, perhaps. But nonetheless, insurers are saying that seller identity fraud is an issue. And insurers are saying that there was a claim recently for over £1 million. So this isn't isolated and isn't sort of in the historical type of claim. It's a current type of claim, and be aware of problems. Alert to red flags: unencumbered vacant properties, quick sales, absence of documents, vague seller clients, etc. Do be aware that Stewart Title has an indemnity policy that will cover seller identity fraud. And again, Freddie and the team can provide guidance with regard to that. Again, from memory, the cost of the premium is relatively low, and where you've got a risk-averse client, or you've got circumstances that put you on notice that there's risk, that perhaps is a way of alleviating or mitigating against that risk. Next thing: cyber-related issues, ransomware attacks, intercepted emails, etc. Again, old hat to me, to be honest with you. Heard about this for years and years. But again, insurers are saying it's leading to claims. It's constantly leading to claims. So cybersecurity, a top priority for everyone in the firm. Lack of file notes, written communication, evidence of advice given to clients, and clients receiving that evidence. Again, insurers refer to the fact that claims are being compromised by poor file management, inadequate retainers, inadequate reporting on title, vague retainer, vague reporting on title, lack of attendance notes or emails where issues are generated and clients contacted as a consequence. So I quote, cannot overemphasize the importance of contemporaneous attendance notes or follow-up emails that carefully record discussions that have taken place and the advice sought or given. Remember, I know, although it can be difficult to jettison a client, there may be circumstances where jettisoning the client is the only safe thing to adopt. Again, it's one of the things that worries me about conveyancing. You know, you're dealing with a client in connection with a transaction. Something happens during the life of the transaction that means that you no longer can act. Sort of extracting yourself from the transaction can cause claims and can cause complaints. So you've got to be careful about that. But just because there is that difficulty and there is that potential resistance as a consequence, you've got to be alive to the fact that you have to ram home to clients areas of risk, areas of issues that are unresolved. And remember, no matter what you say in your retainer, you are under an obligation to advise the client that anything that you discover that is materially adverse to the interest of the client. Natasha, thanks for your question about 8 freehold houses. We're going to have a look at that with regard to apportionment, etc. So we'll come back to that question, but it's a really interesting one that we'll deal with. Inadequate or incomplete reports on title. Again, interesting. The context of a report on title can be critical to the defence of a claim. Review your precedents. Have systems in place to ensure that the content of a report on title is checked before the client receives it. So I'm sure Jordan will shed some light on his view on that issue, because I know that Orbital Witness have a product that assists in that regard. To carry out audits on reports on title to double check that fee owners are achieving the appropriate standard. And with regard to reporting on title and indeed any other form of communication with a client, make sure that the communication is received and understood. And again, with a nod to technology, the report highlights that technology can generate assistance. So pulling data and information from other documents can help populate the report on title and can reduce the opportunity for errors and omissions. Interesting point, just as an aside on that. I was talking to someone who you'd regard as the most unlikely person to welcome the use of technology in the conveyancing process and indeed the use of electronic reports on title. So I was talking to him and I was expecting a great deal of negativity. And what in fact I got was a great deal of positivity. And the stance was this: I'm a very experienced conveyancer. I know what I'm doing, but even I can make mistakes or miss things. And therefore, if I've got any tool or any assistance that can ensure that I miss less or ensure that I don't miss anything, has to be valuable. So there was a willing recipient of the sort of product that Jordan's going to talk about in a moment or two. Failure to act in accordance with lender's instructions. Check your lender's instructions. Check them again before you exchange contracts. Carrying out searches. Again, one of my sort of crusades really is to make sure that you are aware that there's no such thing as usual searches. There are essential searches and there are searches that are property specific, transaction specific and client specific. I know that I'm going to be a voice in the wilderness, but my view is that you should be telling clients about all the searches that are potentially available. I appreciate the resistance to that on the basis that some firms will say, if we tell the client about all the searches we could do, we're going to get bombarded with questions about what they mean, what they do, and whether or not they should be utilised. So I get that as an issue and get that as a problem. So that's a sort of flavour of the things that I mentioned. Dealing with inquiries, we're going to talk about TA6 and TA7 in a moment or two. Failing to advise on ownership as to tenancy in common and joint tenants. With that co-ownership, two things. Do you make sure clients are aware of what you say in box 10 of the TR1? Do you advise joint tenants of the fact that joint tenancy can be unilaterally severed? Missed charges, missed time limits, failing to advise clients properly about SDLT. So in short, what you've got today are the sorts of claims that practitioners have been encountering for years. So there's nothing particularly new, but it's interesting having a look at the report in that just acts as a reminder the fee earners and heads of department and others within the firm, compliance teams, etc., to be alive to the sorts of issues and problems that can arise. So that was the first thing that I wanted to talk about. I understand now that Jordan is with us. And Jordan, what I'd like to do, if I may, is first of all introduce you. Secondly, to thank Orbital Witness for coming along today. And I have known Orbital Witness and Ed and Dimple and the team for a while now. Lovely people to deal with and work with. Great product. And I'm really interested, if you could, Jordan, to share with us a little bit about the Orbital Witness journey. And if you could stick with us, if people have any questions or queries, whether or not you could deal with them either via your presentation or alternatively via the chat facility. So Jordan, if we can get your microphone on, and if you're happy to join us, that would be brilliant.
Yeah, absolutely. Ian, how are you doing? You well?
I'm very well, thank you. Yes, thank you.
Good. So yeah, thank you for having me on. And I suppose to give everyone a brief introduction to Orbital Witness and what we do. We are a prop tech / legal tech startup that started in around 2017, and we ultimately create solutions for both commercial property and residential property. We grew up within commercial property, and we have over 100 firms, over 2,500 commercial real estate users using us on that side. However, over the last 18 months or so, and what's relevant to this conversation is that we turned our heads to the residential side, and we started to have lots of conversations with people like yourselves, heads of conveyancing, etc., to try and understand where some of the common sort of challenges lie within residential conveyancing. And something that came up time and time again within these conversations was title checking being a clear bottleneck in this process. However, when we dug deeper into these conversations, it was all around title checking on leasehold transactions in particular. So that's where we started as a business to create a solution. And what we have essentially created is a machine learning AI model that takes relevant documentation to a case. So on the leasehold case, for instance, a title register, a copy of the lease, any deeds of variation. These documents get put through our model. And then it's our model's job to go around and answer around 70 different questions that typically correspond to 70 standard title checks that you as a conveyancer need to check. So yeah, pretty straightforward in scope. Over the last few months, we've now released a freehold version as well. So firms that are using us are basically submitting all of their purchase transactions through Orbital Witness right at the outset to yeah, help with their title checking process and aid their review.
Thanks for that, Jordan. Jordan, can I ask you a couple of questions if you don't mind?
Absolutely, go for it.
Yeah. I mean, I've seen the product, okay, but how do you see the product alleviating problems that conveyancers are encountering?
Yeah, good question. So, I mean, I've had many conversations with conveyancers, and it's evident that you're facing an ever-growing list of challenges in your day-to-day. And a major issue is one where we're solving is obviously that title checking issue being a key bottleneck, particularly within leasehold. This is obviously causing delays that can extend transaction times, increase pressure on fee earners, etc. Another common challenge that we're obviously hearing is the lack of capacity within firms. Yeah. Many firms are currently operating at full capacity and are just simply unable to take on more work, even if they wanted to. Fee earners are constantly being interrupted by client inquiries, leading to frequent case switching. This obviously then heightens the risk of those errors that you've previously mentioned, as attention is just divided across lots of different cases.
Yeah.
And recruiting as well, another common one. Recruiting just seems to be a widespread issue. Firms are struggling to bring in the necessary workforce to handle this growing workload. So what we're doing at Orbital Residential is, we're addressing these challenges by automating and streamlining the title checking process. So as I say, we mentioned we're using machine learning AI to do this, to pick crucial insights from a property. So things like ground rent increases, remaining terms, subletting conditions. And in turn, this is significantly boosting the efficiency of the title checking process. And I would say our current customers are saving around a 50% time saving on their title checking process. And in turn, that's obviously unlocking lots of benefits for them, including freeing up fee earner time, enabling faster completions, being able to take on more work, etc. But you touched on it there, Ian, as well, about that risk mitigation piece. On the other hand, it's obviously helping mitigate the risk of something being missed, and almost like a second pair of eyes as such. And this is because we're enabling users to instantly see and identify where in the source documentation the answers have been sourced and extracted. So as the end user, you're very quickly able to cross-check and reference the answers that we provide to the source documentation you provide us.
Yeah, I think the other thing, Jordan, that is one of my bugbears is the fact that you're right about conveyancers being under pressure, but one of the things the SRA and other professional bodies are sort of bleating about, with some justification, is this idea about you've got to know your client, and therefore a fee earner has to spend time talking to the client, making sure the clients understand, etc. So if you've got anything that takes away some of the tasks that a conveyancer would normally do, freeing up the client to be freeing up the conveyancer to be more sort of attuned to the interests of the client and helping the client, that has to be a sort of major benefit. There were some other questions that I had as well, Jordan, if we could. Your customer profile, because again, this product has been on the market for a while. Who's taking it up, and who you seeing as sort of the target client or the client that's coming to you with regard to law firms?
Yeah, it's a good question, and to be honest, it's very varied. And I think if any of the previous challenges that I've just reiterated in the previous question resonate, then the likelihood is Orbital Residential is going to be a good fit for the firm. So we're working with a wide range of firms. For example, a few of you may have seen our recent video case study with Simply Conveyancing, obviously a very large firm. They're using Orbital Residential for their transactions, but at the same time, at the completely other end, we also have a lot of smaller boutique firms also using us on a daily basis as well. So these challenges that I mentioned, they're universal. They're affecting every firm of sort of every size, which is why Orbital Residential is adopted widely amongst different variety of size firms.
So surprisingly, there's quite a broad church of client that's coming to you or utilizing product. That's interesting. All right, what about the future? What's next? Subject to confidentiality and all that goes with it, obviously, Jordan. What magic are you and the team looking at next, or what have you got, or what are you thinking of? Or can't you share it?
No, I can absolutely give some insight. So as I mentioned, we over the last few months released a freehold version. So on this version, we're producing reports on title, reports on TA6, reports on searches, etc., with the same format being applied, where you've got answers to a report. You can quickly check where these answers have been sought in the documentation. But likewise as well, within that, we're obviously highlighting key red flag issues right at the outset. We're also going to be adding more document types as well. So we want to look at inquiries, we want to look at draft contracts, etc., incorporate those into the platform. And the way we see Orbital Residential is the way you would see it. It's at its worst state. It's just a constantly improving platform that's just going to grow with conveyancers over time.
Got you. All right. Thanks, John. And last question. How do people contact you? Obviously, I've put your address on here. Are you the main point of contact for people, or is it better for them to visit the website, or what do you suggest?
Yeah, a few different ways. So I think my colleague Paul is going to put a link into how you can organize like a demonstration, and we can have a conversation around how you're currently with how your workflows with the firm, etc., and how Orbital Residential could fit in. Likewise as well, I'll drop my email address into the chat, so please feel free to drop me an email, and we can organize a call, discuss with you your priorities, and see how Orbital Residential can fit in.
That's brilliant. Thanks, John. It's interesting. I've known of Orbital Witness from its sort of inception, as it were. It's been really interesting to see how it's grown, and it has grown vastly, sort of very quickly, which is always a positive sign. Jordan, thank you very much indeed for your time and for your colleagues' time. And Paul, thank you for attending today. If anyone has any questions or queries concerning product of a sort of general nature that might be interesting as far as the forum is concerned, use the chat facility now, or if you want a demonstration or you want to speak to Paul or Jordan, you've got their contact details. Do have a look at the demonstration that is being offered to you, because you really will be surprised by the product. It's really useful and really interesting. So thanks very much, Jordan. Lovely to see you.
Ian. Cheers.
And thank you for your comments. Really kind. Great. Okay. So I've got things that I want to talk about, but I've now got a number of things that have been raised in the forum that I want to have a look at if I can. So first of all, Rena, Land Registry updated its guidance in respect of deeds of variation for rent charges, in that these should now be deeds of release as opposed to deeds of variation. And you're asking, has anyone encountered any issues regarding this? So, Rena, interesting point. Anybody got any comments? Anyone encountered that? While I'm waiting for people to join in on that and the chat facility, just to let you know, very excited about doing a bit of a collaboration project with the Land Registry about training and about issues that are causing problems for transactional property lawyers. So I think the first webinar that we're going to do in collaboration with the Land Registry will be a project about restrictions. But what I'm going to do, Rena, is I'm going to see if anyone raises any points relating to it. And this will be another one of the topics that we'll be doing some training on with the Land Registry. As far as deeds of variation for rent charges are concerned, the other thing I would say, Rena, is the Leasehold and Freehold Reform Act in an amended form, I think, is going to look at giving rent charge payers the same protection as leaseholders in service charge. But I'm just going to have a look at Zara's saying she hasn't come across it yet, and I haven't, to be honest with you. But I'm going to ask one of my colleagues to make a note of this, Rena. I'm going to take it up with the Land Registry. I'll certainly get back to you when at our next forum. And as I say, keep your eyes peeled for this work that we're doing with the Land Registry on it. Okay. Now, the other thing that we've got is Natasha. Natasha, any steer for rights of recourse for 8 freehold houses within a state of 132 flats with a management company not working out an appropriate method of calculation for service charge that ropes the 8 houses. 8 houses of right of ways in arrear, so TP1 have to contribute to service charge, but houses are being overcharged. The only thing I would say here, Natasha, is the first tier tribunal has jurisdiction to determine a reasonable apportionment of service charge. And I don't think it matters whether they're houses or flats. So what I would suggest is if you have a look at the Leasehold Advisory Service website, there's guidance about the various types of application that can be made to tribunal. And I think there is a basis of challenging how the service charge is apportioned. My guess is it's under the Landlord and Tenant Act 85, but it could be under the 87 Act. But I'm sure there's something there that will help you with regard to that problem. And the other thing is, again, as I repeated earlier, government is keen as mustard to try and ensure that leaseholders are getting a fair deal with regard to service charge. So I'm fairly confident that a tribunal would intervene there and would ensure that service charge is apportioned on a just and equitable basis. Hi, Davina. Davina's got a question, and I know there's a question in the Q&A as well. I'm going to come back to that in a moment or two. A and B purchase properties joint tenants, interim charging order made, and a Form K restriction is added to the title against A. No Form A restriction is added to the title by the Land Registry. A dies. Does the interim charging order sever the joint tenancy? How does B now sell the property? Now, the interesting one, an interim charging order, I'm going to check, but my gut reaction is that would sever the joint tenancy. So B now is a tenant in common, and in those circumstances, he or she would be entitled to appoint a new trustee, wouldn't they? That's the answer to that question. I did a webinar on Monday on restrictions, and I'm doing a webinar with the Land Registry on restrictions as well. But that's my view, Davina. Anyone else got any comments on that? All right, thanks very much, Zara. That's great. Casey Chambers, yeah, thank you. Might get Casey to come along sometime, Zara. The other thing, just thinking about that question on the management, have a look at the Association of Residential Managing Agents website. If the management company is ARMA registered or accredited, or if they're RICS accredited or registered, then again, there's a code of practice for residential leases as well. Natasha, that might help you. Okay, anyone missed the note that was made by Zara asking about the Howden's report? Send me an email and I'll send it across to you. Okay, that's great. Now then, there was a question in the Q&A. I want to have a look at that if I can. Dale, hi Dale. What is the position of no search indemnity if after completion a planning application for a neighbouring development is discovered? Usually, let's have a look. The no search indemnity only covers the 4 searches, but what about planning applications for neighbouring properties and any cost of opposition relating to those applications? Freddie, have you seen this? No search indemnity. If after completion a planning application for a neighbouring development is discovered, only covers the 4 searches, but what about planning applications for neighbouring properties? I think, to be honest, Dale, you've got to look at the wording of the policy. Freddie, any comment on that, or anyone from Stewart Title, any comment on it? So I think Stewart Title do offer a no search indemnity policy, but what about the wording? But I'm sure, Dale, you'd have to look at the wording. So I don't think I can give a sort of advice. Anybody else seen this, or anyone else got any comments about insurance policies that are used? Would it cover? So I'm just waiting for people, or perhaps I'm going to revert back to the chat. Zara, I've client buying a property with an extension, no planning or building regs. Seller is saying it's within permitted development, but the extension is separate to the main house and joined by a lean-to. Would it still require planning? Extension is separate to the main, joined by a lean-to. I would always proceed up with caution on that, Zara, and say yes. Until someone gives me a definitive no, I'd be warning my client how do we prove when it was constructed, what should be asking the seller for. Statement of truth, stat deck, invoices, etc. from contractors that were utilised for the work, that sort of thing, I think, Zara. Anyone else? I want to go back to this point that was raised by Dael. Anyone seen that, and anyone got any comments to make on it? Okay, let's assume not. Next thing I've got on my note, land registry data and requisitions. Courtesy of this project with the land registry, I'm now getting positive data from the land registry about requisitions. The biggest area for requisitions is restrictions. A major issue for the land registry who are keen to have the concept of a one-touch application. In other words, an application is received, the application is processed, and requisitions aren't necessary. And you're going to see a major drive towards the land registry being proactive with regard to training. So again, watch this space. In the next forum, I'll be giving you some more details about the collaboration project I'm working on with the land registry on that. Anyone got any comments? But as I say, restrictions are the major issue. The other major issues that they tell me about are names in deeds, incorrect spellings, different names, etc. So there's some of the basic and more fundamental errors that practitioners are making that are leading to requisitions. While I'm waiting for that, something that was put across my desk on Monday, which I've never really thought about. How would you deal with a client who's buying a property near to an airport? Are you going to highlight to them the obvious about air traffic and noise? Are you going to investigate air traffic flight paths? And if you are going to investigate it, where are you going to get information from? Now, I was talking to someone yesterday who was saying that some local authorities will register as a land charge flight path information. And I hadn't heard of that, to be honest with you. I failed to see how it could be a land charge. Does anyone encountered that? So I think Bournemouth was mentioned to me, and the fact that although Bournemouth isn't a busy passenger airport, it's a hub for repairing airplanes and storing airplanes, and therefore there's a lot of air traffic. And again, and I don't know whether it's right, I haven't checked, but they were saying Bournemouth Council will, if you're undertaking a local land charges search of a property close to the airport, will or do record it as a local land charge. And I was sort of taken aback by that. But there's another more fundamental question. Would you warn a client about the fact that a property is close to an airport, or is it so obvious that you're not going to bother? And do you need to warn clients about flight paths? the person that posed the question to me was asked by a surveyor to investigate. So the surveyor in the survey reports this property is in the flight path of Heathrow or Gatwick or whatever. Further investigation should be undertaken by your solicitor or conveyancer. So again, I'm interested. Does anyone deal with it as a matter of course? Do you think we should be doing it? Rather than simply posing a question and creating further headaches for you, you can go onto Aeronautical Information Publications, a website called Anima, and it can tell you about flight paths. So if you wanted to know, you can do it. I don't think there's any way in the world that a conveyancer should be undertaking that sort of search. But I think if it's raised, I think you should be saying to the client, look, you can get information relating to it. Yeah, and Davina, the question is, how frequently is it raised by a surveyor? How often does the surveyor generate this? Yeah, it's not the timing, Zara. It's the fact that your property is on a flight path. And I know, okay, flight paths change, but if you go on this website, it'll show you the variety of different flight paths depending on wind conditions, etc. So, Davina, you've never seen it. I'm assuming, Zara, you haven't seen it. Yeah. But you've had it flagged. You haven't had it flagged, Davina. Has anybody else? Yeah, I think that's right, Anthony. But the point here is that if your property is beneath a flight path, there's a greater likelihood of noise or disruption. Zara raises an interesting point. What happens if your client is averse to noise? Do you tell them about the limitations relating to the searches that you could undertake? Zara, no, I don't think it's time to join Top Gun yet. But it was an interesting thing. I'd never even thought of it, to be honest with you. I thought it was just glaringly obvious. If you're buying a house, you hear aeroplanes above it, or you're aware that there's an airfield near or an airport near you. But then this thing about flight paths, it was just because someone sent me a question. What do you do if a lender says, ask your solicitor to investigate the situation with regard to flight paths above the property that's being bought? Gosh, no, I don't think so, Kate. Definitely don't think so. I think I don't know, one of the Wright brothers, perhaps, Kate. I think that's about my stamp. Okay. Right. Interesting question, isn't it? Goose. Yeah, well and truly. I think goosed, Kate, rather than goose. Okay. Anyway, I just raised it because it was raised to me. Next thing that I want to talk about really is something that someone just mentioned about service charge. In recent case law, there's been a few cases concerning service charge and legal fees being recovered relating to service charge. And the courts, are yet again really hammering down on sweeping up clauses. So the fact you're saying you can recover any legal costs associated with reasonable management of a property, the courts are saying, well, that doesn't allow you to recover all your legal costs. I think what the courts are saying is you should list the sorts of legal costs that the parties envisage that will be incurred, but then leave it open to say that there could be other costs that aren't listed that are nonetheless recoverable. If anyone wants details about those cases, let me know. It's interesting. I don't think, Zara, the issue is about military flying, because I certainly agree that low flying, particularly in places like the Lake District, Derbyshire, the Scottish, the borders, the English borders, etc., horrendous. I don't think it's that. I think it's civil aviation. But again, I suppose if you're selling a property or buying a property in an area where there's low flying in a rural area, again, could that be an issue? Perhaps, I don't know. So do have a look at recent case law on service charge in residential leases. And if you're interested, drop me a note and I'll send you some details. But be careful about sweeping up clauses. Also be careful about making sure that and this was touched on by the point in the question and answer about how service charges are apportioned. I think you should be limiting the scope of your retainer so that you're not giving advice with regard to the method of apportionment or whether the apportionment is in fact fair and reasonable, because you're not going to say service charges apportioned on the basis of floor area. How do you know that how the floor area is described in the lease is accurate? And how do you know what portion of a development that floor area actually is? You're not going to know. It's like my friend, the Building Safety Act, and the issue about what is a higher risk building or a relevant building. We talk about height or number of stories. Same principle with regard to floor area. Who's measured the floor area and can confirm that this property is 5% of the floor area of the building? Impossible in my view. Talking of the Building Safety Act, again, another issue that I want to share with you. I don't know if you probably haven't read the Grenfell Inquiry Report, but did you see some of the headlines about it? There's no doubt in my mind that the government is going to change the definition of a higher risk building. And I think what they're going to do is throw out of the window, pardon the pun, height and number of stories and start talking about occupants. So you might have a building that's significantly lower than a higher risk building, but occupied by vulnerable residents, in which case that building will become a higher risk building as a consequence. So watch out for that. Again, the other thing with the Building Safety Act, is that building safety risks, the definition of building safety risks, I read somewhere that the old government was thinking that this was a sort of transient term, and that it might be over time regulations were introduced that sort of widened just what a building safety risk is. And I'm sure that's the case if something else is discovered that leads to fire safety risks or other types of risk relating to the building. We'll see the concept of a building safety risk being expanded. Right, I'm just looking at Zara's comment here. My concern is that we're happily being given building regs signed off by developers, but no one is going to know until something goes wrong. Well, again, I think, Zara, the Grenfell inquiry report highlights the fact there's got to be a sort of wholesale reform of the law relating to development. And I think, that's one of the things, the lessons learned, one of the key lessons learned, this idea about, building houses, building flats, etc., cheaply in order to fulfill the demand for housing and demand for profit from developers has to be sort of curtailed. And I think there has to be more attempt made to get back to sort of basic morality and providing safe homes for people. But yeah, that's true. Okay, anyone else got any other topics that they want to discuss today? So there were the issues that I wanted to raise. But has anyone else got anything else that they want to talk about? Other things I'm dealing with at the moment that are interesting, some issues with regard to restrictive covenants on Section 84 applications. And someone was saying to me, do I, as a resi conveyancer, have to, in my report on title, tell a client when I'm listing restrictive covenants that a property is burdened by, about the fact that the covenant could be bought out or an application could be made under Section 84. And if I'm buying a property for a client that has the benefit of restrictive covenants in connection with other land, should I be telling the client about the potential risk of an inability the ability to lose the right to enforce the restrictive covenant? Again, that's something that needs to be considered. Someone's just putting something in the chat. I want to have a look at that. You're getting lots of queries about challenging service charge. Well, there's an interesting question, Zara. Do you, in your report, tell clients about the various opportunities that they have for challenging service charge, administration charges, etc.? I'm conscious of the fact that in doing that, we're going to end up with a situation where we're providing too much information to clients and key messages are getting lost. But I think in a report on title, there needs to be a line or two telling the client about the fact that they have statutory rights to challenge service charge on the grounds of reasonableness or otherwise, and also that we've got the right to challenge administration charges, etc., etc. So not an essay, but just a line or two about the opportunity to challenge and perhaps reference the Leasehold Advisory Service website or the Association of Residential Managing Agents website that contains further information. So Zara, I'm going to ask you the question, do you raise that in your report on title or indeed in information about residential leases? And anyone else, how do you deal with it? And Zara, I know you've got your hand up. Is that relating to that issue or is it relating to something else? Yeah, you do. Well, I think you've got to put a line or two. Davina, that's a really interesting question. Has anyone had queries or complaints from clients who've bought shared ownership flats? Davina, I would direct you to the Leasehold Knowledge Partnership. Have a look on there and see if anyone has raised that on that website. And so Zara's saying all the time it's an issue. So again, with regard to that, all right, thanks for that, Zara. Shared ownership resources, thank you for the tip. That's great. So Zara, what are you saying to people if they have these queries or complaints? Is it a question of just drawing awareness to clients who are taking shared ownership leases on about this issue? On the service charge point, Davina, again, something I always say to practitioners, you should be telling a client that an obligation to pay service charge is a contractual commitment to pay unascertained and unascertainable future expense. Got to do that. Yeah, of course. Someone hopefully will be unmuting you, Zara, or I think I have potentially.
Hi, Ian.
Yeah, hi, Zara.
Yeah. Yeah, I do give that advice only because I've seen so much of where it goes wrong and people coming back to me. I've got a separate report reporting on the actual LP1 pack, explaining the questions, explaining Section 20 notices, even if there aren't any, just so that people are prepared and know what to expect. I've now put in the big warning about service charges, potentially being a blank checkbook for landlords, and what people need to do. I don't go into depth about it, but as Davina's saying, because of my shared ownership experience and I write for shared ownership resources, I get an awful lot of people contacting me about the service charges in shared ownership flats. I had a lady contact me, her mortgage and service charge payment from when she bought it 2 years ago has now gone up by £360 a month. It's meant to be affordable housing. So I try and talk at anybody who's buying a flat out of it. And with the houses, I've got a housing association who basically use complex legal structures. And I call it a complex legal structure because to the person on the street, they don't understand head leases and under leases. So to them, that would be complicated. So I'm calling them complex legal structures. And I just try and explain to them that where you've got these kind of, setups, and I've got a little leaflet that I've produced that I hand out to them to sort of explain to them where the housing association is not in charge of looking after the building. They are not going to get much help trying to challenge the charges because obviously it would cost the housing association. They don't have the money. And they, quite frankly, they don't care because the shared owner has to pay. If they don't pay, it gets taken away. End of. So it's, I'm on the Shared Ownership Council, and they've basically said, the model is this: the shared owner has to pay everything, and that goes to the warning to my clients or anybody who's buying that, if you don't pay, they'll take it away. But the finance people don't warn them about the annual increases, not just in rent, but service charges. And there's a really good explanation on the Shared Ownership Resources website about RPI and how that increases. And during the pandemic, it increased 16%. And so that monthly figure went through the roof. And the government said to the housing associations, you need to cap it at 7%. Some did and some didn't. So you can see what a mess it is. Sorry about the rant.
No, Zara, you raised an interesting point there. I say to practitioners that where you have a service charge or a ground rent increase that is connected to any form of indices, retail price index, rate of inflation, interest rates, etc., you don't know what the interest rate will be, the inflation rate will be at the point that the ground rent review takes place, or when the increase is calculated or formulated. It's one of my grouses with ground rent reviews. It doubled every 10 or 15 years. The guidance was, if you have such a clause, ask for it to be converted so that the ground rent increase was linked to retail price index or interest rate, etc. Well, all right, it's not going to be as draconian as the ground rent doubling every 5 years, 10 years, etc. I concede that, but you still don't know what the ground rent will be when the review takes place. The other interesting thing on that point that you've just made there, which has just reminded me about something, I'm doing some work at the moment with regard to the Building Safety Act. And there's a thought that with regard to qualifying leases, if a service charge is a fixed service charge, it's not a service charge, a variable service charge, and therefore the lease can't be a qualifying lease. Because if you look at the Act, a qualifying lease has to have a service charge as defined by the Landlord and Tenant Act 85. And if you look at the Landlord and Tenant Act 85, it talks about a service charge being a variable service charge. So if it's fixed, it's not. And the other things are to watch out for, and everyone else to watch out for, of course, if you've got a new lease, so you can't have a monetary ground rent, you're seeing some landlords imposing a standing charge as a management fee. So no matter what management time is spent by the landlord, there is a flat fee that is payable to the landlord by way of a standing management charge. And really all the landlord has done is thought, well, I can't charge a ground rent, so I'm just going to charge this standing management charge as a management charge, and therefore it's not ground rent, and therefore I can claim it. Yeah, central modern form of lease. Did the land registry try this just before prescribed clauses went live? Was there not a standard form of residential lease that was mooted? I seem to think it was, Interesting point anyway. Yeah, shared ownership leases, they are common, Rena. You're quite right. I don't know whether there'd be an appetite, to be honest, Zara. Again, I think, what this government's like, I don't know, but the old government was certainly very reluctant on upsetting landlords too much. And therefore, I think there wasn't a lot of appetite for them, whether there is now. The other thing I would say about the current government is I've got a sneaky feeling that common hold is round the corner. Sneaky feeling about that. There might be, yeah, Zara. Good point. Yeah, good point. Who knows? Who knows, to be honest? But I'm sure that issue was muted when before prescribed clauses went live, and prescribed clauses went live and everyone sort of forgot about it, to be honest with you. By the way, Zara, thanks very much for the heads up about shared ownership resources. That's really useful for people. Thank you for that. Okay, anyone else got any topics? I'm really interested about what things are causing problems. While I'm waiting for people, are people busy at the moment? Obviously, holiday season long gone, or gone, not long gone. Are you finding that there's a lot of work out there? Are you finding this issue with regard to new government is getting people a bit jumpy? Or the negativity about what's coming in October in the budget, again, generating negativity? What's the word with regard to market? And again, Dial, I noticed no one has sort of come back to you with regard to that question that you've posed. I don't know if anyone can. What I'm going to do is take a picture of the question, Dial, to remind me that it's something I need to research. So I'll just take a photograph of that. I don't know how to screen save when I'm on Teams, unfortunately. It shows you my ignorance, but never mind. Right. Kate, thank you. Don't feel as if I had the usual lull in the market, which we usually get. It's been super busy throughout. Yeah, I think it has, Kate. I think it really has. And again, it was something that Jordan was mentioning about, recruiting and getting experienced people to sort of come and join the team. How are you finding that? I might get someone actually who's an expert in the sort of recruitment field to talk about that in a future forum. Could be quite interesting. But certainly, Kate, that's the message I'm getting. People are busy. And of course, during the summer months, we're busy because we've got colleagues, etc., on holiday and we're covering. But I'm not seeing a sort of drop off at this point in time on the basis that people are coming back and work's being shared. So it's interesting, isn't it? Okay, anyone else got any questions or issues? Some more questions in the Q&A. Let's have a look. There's a comment. Yeah, Zara, I think a lot of things with indemnity policies do cover the property and relate to the property and not adjoining properties. And I do think you do check policy wording. I think that's so important. Any other questions or any other issues for anyone? There's again something else in the chat that I want to have a look at. Oh, I'll repeat one. Leasehold transactions complete in a month. Building Safety Act leasehold transactions, Zara, in a month. Again, I'm seeing more and more firms doing BSA related work, and just some comments on that. One, you can charge more for the work that you do. Two, you should be telling both buyers and sellers that there's a likelihood that the transaction could well abort and that there could be sort of further hurdles and additional hurdles that you're encountering with regard to BSA work. So I don't know if you do that. I know Zara is saying she doesn't do it. Anyone actually doing BSA related work at the moment? Firms that I deal with, more and more firms are saying reluctantly we are doing it. So there's more of that, which is interesting. Yeah, well, leaseholder protections aren't guaranteed, but equally, Zara, you could say that, you know, the statutory protection with regard to reasonableness, etc., doesn't provide protection either, does it? It doesn't provide blanket protection anyway. I think the Building Safety Act, you say to the client, look, there's the potential for some protection for some leases, just as if it's a higher risk building, there's a risk that service charge is going to increase. Yeah. Interesting. Okay. I'm conscious of time. Anyone got any more questions or queries? While I'm waiting, one or two things. Firstly, delighted to see so many people attending today. It really is brilliant. The more the merrier, to be honest with you. So do come along to the next one. Do be aware of the fact that Stewart Title, Freddie and the team are there to help you with regard to your title indemnity insurance needs and questions. And do be aware that as far as these forums are concerned, they're your events, they're not mine. So I raise questions as talking points just because people ask me about it. But what I'd be delighted to see is people sort of firing questions at me in readiness for next time, so that we've got lots of interesting things to talk about. Developer remediation work. Well, yeah, it is. I mean, the problem is, Zara, that you've got landlords that don't want to dip into their pockets. And the Building Safety Act means that they're more likely to dip into their own pockets. And therefore, there's a residual resistance with regard to carrying out remediation work. So to an extent, no matter what the Building Safety Act does, the net effect isn't the positive effect that I think the Act was designed to deal with. I don't know on the common hold point, Zara, I'm just getting a vibe that this government is thinking common hold might be the way of resolving the issue. Victoria, hi Victoria. Many do not understand the BSA, so encountering landlords issuing certificates after an issue in LP1, when the client serves a certificate, they refuse to reissue. People issuing leaseholder deeds a certificate, but not. Yeah, it's the Wild West, isn't it, Victoria? Absolutely the Wild West. And I don't see it sort of steadying anytime soon. So I think what you've got to do is you go back to basics, Victoria. You're careful about your retainer, and you're careful about your report on title, and you're highlighting to client risk and highlighting to clients their vulnerability with regard to your limiting liability as a firm in connection with BSA related issues. So, you know, put simply, you're saying to the client, look, the Building Safety Act Schedule 8 might afford you some protection if the building is a relevant building, but A, I can't guarantee that this is a relevant building, and B, I can't guarantee that you are purchasing a qualifying lease, and I can't guarantee that the content of a landlord certificate is accurate and correct, and nor can I confirm that the landlord's knowledge with regard to remediation work for relevant defects is accurate and complete. So all the time you're just throwing at the client the fact that, you know, they're buying an unknown quantity. And all right, that doesn't help the client. And all right, some clients will just not appreciate the risk and their vulnerability and just proceed anyway. And all I'm saying to you is, well, you know, we've got to throw the buyer to the lions, as it were, and think about protecting ourselves. So, I mean, it's a point Zara touched on. You know, would any reasonable conveyancer buy a property, flat or an apartment in a higher risk building? There's a question. So let's put it as our final question of the day. Would you buy a flat or an apartment in a higher risk building? Anyone? Wouldn't touch it, would you? Exactly. And yet, I'm sure we've all got clients that are. And, you know, are you entirely comfortable that if you bought a flat or an apartment in a relevant building, that you are ring fenced for protection in connection with remediation costs for relevant defects? The answer to that has to be a no as well, doesn't it? On that happy note, ladies and gentlemen, I'm going to finish. And what I'm going to say, first of all, is a massive thank you to Freddie and the team at Stewart Title for organising these events and allowing us along. A massive thank you to Jordan and the team at Orbital Witness for coming along as well. Have a look at the website, speak to Jordan and Paul and the team, and go from there. And thank you. Come along to the next one. Email me with questions or queries. Thanks, Kate, for that point, and Lisa as well. Yeah, I'm uncomfortable. But, you know, they are desperate and they fall in love with flats and apartments, and, you know, everything else goes out the window, doesn't it? Thanks, everyone. Listen, brilliant forum. Really enjoyed it. Stay safe and speak soon. Thanks, everyone. Drop me a note, by the way, if you want that stuff from Howden Insurance Brokers, and I'll send it to you. Thank you. Bye-bye.